next case is Jenkins versus Jenkins, and each side will have 15 minutes to argue, and the appellant may reserve up to 5 minutes. Just please let me know. Thank you.
Good morning.
Good morning.
Robert Cabrera on behalf of the appellants Kelly and Tim Jenkins, the paternal grandfather and the paternal step-grandmother. I would like to reserve perhaps 2 minutes for a rebuttal argument.
Thank you.
Your Honor, this matter is before this court on the grandparents' complaint for visitation and companionship with the minor child, their granddaughter, I will call her AJ, her child. I should note to the court that the paternal step-grandmother's name is Kelly Jenkins, and likewise the mother of the child's name is Kelly Jenkins. So,
It's very confusing.
confusing for the briefs. It may be confusing this morning. I will try and say grandparent and mother as much as
And
possible.
please say child, but not
Child.
the child's name, please. We appreciate that.
Your Honor, I would submit to this court in terms of procedural posture that the grandparent seeking visitation had an obligation to file a complaint with the court seeking grandparent visitation rights pursuant to 3109.12 in this particular case, because the child was the issue of an unwed relationship. And likewise, the grandparents would then have to demonstrate to the court that visitation and companionship with them and the minor child would be in the best interest of the minor child. The statute references 3109.051. I'd submit that they did in fact file a complaint. Procedurally, it was exact. There was an evidentiary hearing prior in front of the magistrate where I would submit that my clients demonstrated presented evidence. The 3109.051 requires an additional burden to demonstrate that the moving parties have a vested interest in the child's welfare. I would submit to this court that at hearing on this matter, that my clients did in fact demonstrate that a companionship and visitation schedule would be one in the child's best interest, and that they did in fact have a vested interest in this child's welfare. I would submit to this court that they did so. They met their burden by presenting evidence at hearing on this matter in the form of pictures of their interaction with the child at important functions such as school events, extracurricular activities, attending these events with the granddaughter, the other events of significance, family outings, vacations, holiday, family reunions. They spent the summer in Florida.
Excuse me.
Yes.
Is there any ruling out there anyway that prevents the grandparents from going to any of the child's school events?
Well, one would be knowledge. If they had knowledge of it, they would go. And it is true that there was an instance where a dance recital, it was a yearly dance recital that the grandparents had attended on numerous occasions. And during this estrangement period from September, I think the recital was in the spring, they did in fact attend that, knowing that the event took place.
But if it's a public
It was a public event, although the mother was not happy. It was a public event, and they attended it. They would not be able to know, though, about certain events, even school events, without some kind of knowledge. And schools are just not permitted to release that information.
You also mentioned that this was filed under the statute because she's an unwed mother, the grandparents can ask for visitation. But this is mother's parents, or her father anyway, and her stepmom, right? This isn't the father's.
No, it is not the father.
Parents.
Father was served, and he elected not to participate. He did not attend any of the hearings, and there's no testimony regarding the father.
So it's not paternal grandparents, it's maternal.
I'm sorry, I'm sorry, Your Honor, it is maternal.
Maternal grandparents.
Yes. Likewise, they presented pictures to support their position. They had the testimony from other family members, an aunt, and other relative regarding factors. They themselves in their testimony demonstrated that they had knowledge of the child's behaviors, the child's concerns. They addressed how they attended to those concerns and that behavior. They demonstrated knowledge of the child's interests and habits.
Counsel, I'm going to interrupt you with everything. I don't know that the issue here is that anybody contesting the fact that these grandparents love this child and have a good relationship with her. It's just a matter of abiding by mother's wishes and the inappropriate conduct alleged between the other child in the home, and the granddaughter.
I'm glad the court brought that to my attention because that's where I was going.
Okay.
That is essentially where we are at. My assignments of errors indicated that I believe that the court abused their discretion in regards to her treatment of the mother's objections. Let's assume, based on my short presentation and the court's knowledge, that they did meet their statutory burden in regards to presenting evidence of the interest in the welfare of the child, that they did present evidence regarding best interest pursuant to the specific factors. The issue before this court is mother objecting, and even though it is only one of the factors, I believe that it was in this particular court's decision that she put too much emphasis on the mother's wishes in this particular matter. At the objection hearing, and it was a quite long hearing on the objections in front of the court, it's a 62-page transcript. The court initially considered an interim order of visitation. The court urged us to sit and discuss and try and negotiate some type of visitation with the child. The basis for that is because this was not a sort of a babysitting relationship between the parents and the child. This was not grandparents and the child. This was not a casual relationship. They had been involved with this child in a loving and nurturing relationship from the time the child was born until this incident occurred. But an incident did occur, and I believe that that was the basis, essentially, for mother's position that she did not want the child to visit with her father and her step-grandmother. The court indicated Troxel. I know Troxel. I'm going to look at it through Troxel. Your Honor, but of course in Ohio it's the Harold versus Collier case that the Supreme Court has taken Troxel, and it's, which was out of the 9th District. The truth of the matter is that the Troxel court, or the Collier court, it made a few assessments as well. They indicated that the plurality in Troxel declined to define the precise scope of the parental due process rights in the visitation context. Ohio courts are obligated to afford some special weight to the wishes of the parents of the minor child when considering petitions for non-parental visitation pursuant to 3111 or 310912. The idea that the court has to offer some deference or some special weight also indicates that it cannot provide the mother too much weight in regards to that. It is not determinative. They were very specific, and that Collier was very specific. The analysis of best interest, nothing in Troxel suggests that a parent's wishes should be placed before the child's best interest. And that's what's here. The Troxel case has been around for, I guess, 19 years, a 2000 case. And I hear quite frequently in the domestic and custody situations that people know Troxel. I'm beginning to wonder. Troxel involved the grandparent statute, but likewise, it involved a family. The Scalia's dictum for the decision was that the sanctity of the family relationship and not interfering with that. I accept that. That's not what's happening here. If this was a married case, I would not be before you. My clients would not have a standing to bring a case before this court. This is a child born out of wedlock, and the court has the authority to override the mother's wishes in this matter. I don't think that they do. I think sometimes they believe that the mother's wishes.
She hasn't been found to be unfit, though. And she's not saying you can't go because there's fleas over there. I mean, I guess what the court's looking at is what are mother's wishes, right? And the difference is that pretty much the court's saying mother's wishes don't outweigh. You're saying it does outweigh the child's best interest.
No, I'm thinking the court's decision is the mother's outweighs the best interest of the child. I think the court should sit there and say, I'm looking here at a situation where this child's been involved with these grandparents for a substantial period of time. It's not a casual relationship. They've been since birth. They've stepped into the shoes of Uncle Parentis. I have to be careful in this regard. It's not someone coming out of the desert after so many years wanting to visit with these children. This is a relationship. And the idea of an abuse of discretion in terms of arbitrary, think of the ultimate decision is that the mother can refuse any contact between the child and the grandparent. I don't believe that that is the proper result in this case, and I don't believe that it is what's best for this child. And I don't see where the
But mother did, suggest like supervised visitation. She suggested some things that would try to alleviate her concerns and still maintain the relationship between the grandparents and the child, and that was rebuffed, right?
She testified to that, but there was an attempt at counseling that my client did attend. My client left because the former wife was there. They had been divorced for 20 years, and somehow they were going to address the divorce.
Well, she's a maternal grandmother, isn't she?
Yes, of course. But that's not what was presented to him. I guess they had been divorced 20 years ago, so apparently there obviously is underlying tension between the father and the mother. The father would say that it was her lifestyle that he had problems with, that it was the impact on the child. All of the testimony about that all of their differences involved the child. The different jobs, not being able to maintain a steady job, not being able to maintain a steady home environment for the child, casual relationships. All of these cause stress in the relationship between the two of them. Grandfather would have been pleased to address these things. Perhaps he wasn't, and I think his testimony was that he didn't expect to have to go back there and rehash the divorce for 20 years prior. But the fact of the matter is, there was also discussions regarding visitation even that day. The court suggested that we consider that. Mother did not appear. Grandparents appeared, mother did not. So,
Counsel, you mentioned that the grandparents stood in local parentis. Was that argued below?
in terms of what Your Honor was presented.
Well, there's a difference, is there not, about what you do when someone is arguing, I'm essentially in local parentis status here because of the situation, versus I am a grandparent and it's in the child's best interest to have contact with me. So you mentioned that, and I just wanted to know if below there was an argument proffered that the grandparents were standing in local parentis. I haven't seen the record, so I don't know the answer.
It would not be a procedural one. It would not be as in any juvenile case, an abuse of neglect dependency, where someone would come and establish that. No, that was not part of it. They just testified that there were periods of time, mother's rehab, for example, where the child had a room inside the home. She spent extensive periods of time, not only weekends. She spent the weekend of this particular incident. She spent the weekend with them at her own place, and they would take the child to different doctor's appointments or what have you. Father was not around, and they assisted mother in any way that they could.
Counsel, you're in your rebuttal time now, if you want to say that.
Thank you, Your Honor.
Good morning, Your Honors.
Good morning.
Counsel. May it please the court, Attorney Brandon Oliver on behalf of the mother of Kelly here, Kelly Jenkins, Kelly with a Y, not with an I. Your Honors, the case, as I know there's already been some questions from the bench directed to appellant counsel, is one where I believe this is not a situation, and there's no dispute that it's a situation where these are grandparents that have come out of the desert. These are grandparents who had contact with this minor child, AJ. During the course of that contact, an incident is alleged to have occurred with another minor child who resides in the grandparent's home, that child, DJ. The issue that was the precipice for all of these court proceedings had to do not only with two incidences involving the minor child, DJ, against AJ, but also the grandparents, and most particularly grandfathers, refusal to address those situations in a manner that mother felt was appropriate. Part of the basis of the appeal and the objection that seemed to take place here was that the appellate's perspective was nothing occurred here, Children's Services got involved, and Children's Services saw no issues. The transcript, and I know my own argument reflects that that's not the case, that in fact Children's Services stated that the minor child, AJ, made a disclosure regarding the allegations against DJ. Children's Services, as I'm sure this court is very aware, is an often overburdened agency, and in this situation the testimony showed that these are children living in separate homes, so there was no immediate risk of reoffense so long as they were kept apart. That everybody was involved in counseling at that point in time. In fact, mother and this minor child have remained in counseling, addressing issues. And that they believed that the parties would be able to resolve that, the child would not be in harm's way. And so Children's Services did not believe that they needed to continue to be involved because the issues at hand were being addressed. And then when asked about what they thought would be appropriate, the caseworker from Children's Services actually said that they thought they would be comfortable with a level of supervised contact. I think anytime in a grandparent visitation case where supervision is a necessity, that should raise a red flag for the court, and I think that it did here. As this court has pointed out, there's certainly been no finding of unfitness by mother. What we have here is a single mother who's worked in a healthcare facility, who all of the witnesses, including all of the witnesses for the grandparents, say has always met the needs of this minor child, has always housed, clothed, fed this minor child, is a good mother to this minor child. No findings of necessity of unfitness. She did have some substance abuse in her far past, I think 8 years ago. Testimony was that she's maintained sobriety. Nothing was brought to contend against that. Actually, the weekend where the last incident between AJ and DJ took place, I believe she was testified that she was attending a conference related to her ongoing involvement in sobriety and sobriety-based activities. As this court is certainly aware, while Troxel establishes this fundamental right to parent, there is no fundamental right to grandparent. That's established through statute. Harold Vercollier clearly sets out that we need best interest factors, but additionally we have Oliver V. Feldner, who states that there needs to be some governmental interest, and that governmental interest is deemed to be protecting this child from harm. These are not grandparents intervening saying, something happened at mom's house and we really feel like we need to keep an eye on that. In fact, it's quite the opposite. What's gone on here from mother's testimony is certainly this de-evolution from the grandparents just saying maybe we'll address this to a complete and absolute denial. The sentiment of grandfather Tim Jenkins, as he testified and admitted to on the record, was, my house, my rules. He did not want to take mother's consideration into how her daughter would be treated or supervised and monitored in his home. With 2 separate allegations, she found the appropriate remedy then would be to not allow her daughter into that home. And I believe any parent acting in the best interest of their child would do it. The record reflects, and this court's already addressed, that mother continued to make ongoing efforts to try to rekindle a relationship. She tried phone calls with the grandfather. The phone calls turned into mother being harassed about court proceedings. She attempted to visit with grandfather. Not only did he tell her he doesn't need a babysitter, he says it quite explicitly to her. She made arrangements to meet at her grandmother's home, Tim Jenkins' mother, and for a holiday, and he'd see her granddaughter. On the first occasion he has to see his granddaughter, which is his great concern, he brings the other minor child, who mother's not okay with being there. He doesn't make her aware of that, he doesn't ask her that, which just really goes to, I think, corroborate the sentiment. He's going to do what he wants to do when he wants to do it. He thinks...
Counsel is DJ an adopted child?
He is an adopted child. I have my understanding and testimony showed that he was a family relation of the step-grandmother who was placed with with Tim and Kelly Jenkins through Children's Services, and I believe they have legal custody. I don't believe that he's legally adopted, but they are his legal custodians, and they've been raising him from a relatively young age. He's about 5 years older.
Right. But it wouldn't be unusual for a parent to bring their child to a Christmas celebration.
This was not a family gathering Christmas celebration. This was an arranged visit that was made by mom with her father because he hadn't seen the child, because she admits they had a relationship. In fact, testimony shows that there was at times a very rocky relationship between mother and the grandparents, and I think that's really important to look to here, because despite any issues between mother and the grandparents historically, she maintained a relationship for her daughter with those grandparents. She didn't let her differences be something to intervene. I know a lot of times as a family law practitioner, and I'm certain this court's seen more than its share of it, a lot of these cases have to do with somebody looking to use a child as a pawn or a power struggle, or if you're gonna hurt me, then I'll hurt you. That's not this case. This case, everybody says, yeah, there were times when we didn't get along. But in spite of that, those were my problems with my father, and I'm gonna work through those and attempt to work through those. Additionally, the counseling, I believe that the counseling that appellate counsel referred to where the maternal grandmother was present was a previous counseling experience, not the counseling experience directly related to this minor child and these grandparent visitation rights. Grandfather outright refused. In fact, it's his text messages, which were submitted into evidence, which show his outright refusal to attempt to attend any counseling. The one dance recital that was attended was someone, mother I know certainly felt bombarded. It was a public event. There are no court orders refuting the parents the grandparents from being present. Mothers never saw litigation. What she saw the entire time is for them to come to an amicable resolution, for them to try some counseling, for them to make sure, for her to feel safe and for her daughter to feel safe in the space where her grandparents are, in light of the fact that this other minor child resides there. I would like to address briefly, I know it was not brought up in appellate's argument, but it was in their brief, this argument of due process and equal rights not being presented. I believe that I addressed this correctly and thoroughly in my brief. It's Rugula Die v. Die. There's a case essentially talking about equal protection in parenting cases, and that case, quite distinguishable from the case here, is one that set forth that unmarried parents are similarly situated persons to married parents, and therefore should be given equal protections. There is nothing in that case that sets forth any sort of fundamental right or equal protection for grandparents to parents. I think everything in the law actually says that these are not equal parents. That's why we have this special weight given to the parents' considerations in a best interest analysis for grandparent visitation. The abuse of discretion standard that needs to be met by appellant here is one where you're saying that this is unreasonable. There's no reasonable basis, is what the grandparents would like to say. The reasonable basis here has to do with the fact that we have an actual disclosure from a 4.5-year-old child at the time that everything takes place about something being unsafe and these ongoing issues with the grandfather to not wish to remedy them. In fact, upon review of the transcript, this court will actually see that the magistrate at the hearing had to reprimand father for staring down mother and myself actually at counsel table while other witnesses are testifying. This is just seems to be the ongoing nature of his demeanor and behavior. He's going to do things how he wants to do them, that essentially mother should subject herself to his wishes. That's not the case here. I know this court's not looking at this as it sits today, but certainly I know that mother actually continues to work on trying to create a safe space and some contact for the grandchild and the grandparents. However, she does not believe that based on the lack of cooperation or just willing to follow her wishes in this situation and other issues historically, some different issues when the child's small about bathing the two children together even though mother asked them not to, some foods that mother requested that they not feed to her daughter that the grandparents thought they would know better and feed. I understand the role the grandparents have called as a parent myself. My mother certainly has 40 years head start on me in parenting, and there's times when I know she likes to interject herself with the grandchildren, and these are certainly her family and her lineage. And some of those other things, the bath, the food, while those are aggravating, those are things that mother was willing to oversee. She said, listen, please don't do this in the future. She never terminated visits over. She's never terminated visits over anything until this incident, which as a parent really ranks as probably some of the most egregious and serious concerns that we have for our children in protecting their safety. Again, mothers continue to try to take efforts, simply don't believe that a court order is appropriate in this matter because we have a mother who continues to act in her daughter's, the child's best interest in spite of any of her own differences, and at this point decided it was in that child's best interest to not have that regular contact based on these allegations. As such, I believe that there's a very reasonable basis for the court here. One last point that I would like to address, it was brought up a couple times about at the objection hearing, this recommendation from the trial court that they consider an interim order. A full review of the transcript would actually show that the trial court at that point in time had not reviewed the transcript. They had read the briefs that we had presented and they heard our argument. And it was an exceptionally long objection argument. I believe it went somewhere near 2 hours actually. After reviewing that, there was no interim order put on by the court. They certainly had the opportunity. There was quite a while before an objection decision was made, and that court, certainly of their own accord, made us aware on that record that if they saw fit, they could subject us to an interim order. They placed no order. I believe that silence, especially after having the opportunity to review the transcript in full and not just our briefs and our oral arguments, is resounding confirmation of the lower court's decision and why we're here today. So as such, Your Honors, we would ask for you to uphold the decision of the lower court and not order any grandparent visitation at this time. Thank you. Any questions?
Yeah, I don't believe so. Thank you.
Thank you, Your Honors.
Counsel, you have 1 minute and 48 seconds.
All right, thank you, Your Honor. First of all, yes, it was legal custody, it was not adoption. My understanding is it was a Christmas holiday party. They weren't even sure mother would appear because she had indicated to the grandmother that she was not going to show. Your Honor, the mother had many issues, just to clarify the point, issues with her father, not the maternal step-grandmother. She was the buffer and she sort of eased the situations, the relationship between the two. But they had an ongoing for years prior to the child being born as well. She had issues, concerns, she raised them and they addressed them. In this particular matter, and I'm glad counsel indicated about the domestic relations court, custody courts trying to leverage themselves with allegations, whatever they're difficult to prove, what have you, because it does happen too much. I did not want to go into that. But the truth of the matter is, and we had people testify to the court, there was a disclosure, allegations. My clients were trained, they had a background check, a home study, they were trained. They did what they are obligated to do and what they are trained to do. The agency investigated, they shut the situation down, and in their view did what they were supposed to do based on their training.
But didn't the caseworker testify?
She did testify, I
And
think the supervisor.
Would you agree that the substance of her testimony was because they were in different homes and so forth, that was the reason why you closed the case?
Well,
It's not the situation where the child lives with the alleged offender all the time.
a safety plan is put in place, recommendations are made, and then they're followed up. It's true. But the truth of the matter is that their actions were not unreasonable. Their actions were what's required. The issue seems to be father's indication that it's my home and I'm going to do what I want in my home. Your Honors, we may be grandparents or parents, but in my home, I make the rules. You don't pull the dog's tail, you don't pull the ear, you don't jump on the furniture, you eat what's in front of you, okay? If you don't like that, I'll put you back in your car and take you home to your mom.
And
I
counsel,
can
you're
see
out of
that my
time.
time is over. Thank you, Your Honor.
The court will take the matter under advisement, issue a written opinion that will be sent to both sides as well as released on our website. Thank you so much.
Thank you, Your Honor.